Hi children, I am going to continue the lesson Human Rights and Fundamental Rights. Now let us have a quick recap of what we learnt in the part 1. We learnt about the importance of the human rights and fundamental rights and what are the fundamental rights granted by the Indian Constitution and how they are protected by the courts, that is judiciary. And we also learnt about the UDHR, Universal Declaration of Human Rights, and the fundamental right to equality, which provides 5 types of rights: equal protection of law, social equality, equality of opportunity, abolition of untouchability, and abolition of title. And the second fundamental right is right to freedom, and this right to freedom provides 6 types of freedoms, and we also discussed about the 6 types of freedoms which are granted: freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations or unions, freedom to move freely within the country, freedom to reside and settle in any part of the country, and freedom to practice any profession or to carry on any occupation, trade or business. So far we have learnt about this. Now let us continue the lesson. Right to life. Now, let us see what is this right to life. Right to life is guaranteed by Article number 21 of the Indian Constitution. Article 21 provides right to life and personal liberty. And this right includes protection with respect to conviction for offences is guaranteed. Suppose we are doing some crime, we are convicted. That this right gives us protection against such conviction. That means we have the right to live. Each and every person in the country has right to live, and personal freedom is also granted to each and every person. That is why no one can be given any punishment which is more than what is prescribed by the law of the land. That means only the punishments which are prescribed by the courts of law, they can be given to any person. Even if a person is convicted of any crime, he can be awarded punishment only according to the law, not as they like. And no citizen can be denied his life and liberty except by law. Only by the courts of law, the life and liberty of a person can be denied. Otherwise, it cannot be denied by any one or any organization or any institution. And this means that a person's life and personal liberty can only be disputed if that person has committed a crime. And even if he has committed a crime, it should be according to the law only. He should be punished only according to the law. And this right to life does not include the right to die. We cannot say that we have a right to life, so we have right to die also. And that is why suicide or making an attempt for suicide, both are crimes. In 2002, the right to primary education became a part of the right to life, because without education there is no life. So this right to primary education has been made part of the right to life in 2002. And here the governments are responsible for providing, according to this, the government is responsible for providing free and compulsory education to all the children between the age group of 6 to 14 years. And this makes it necessary for the government to provide schools. The government has to arrange for the schools, and the parents must see that the children, they attend the school. The parents must be interested in sending their children to schools regularly, and then only this right can be enjoyed. This right has been added because people feel that all children should have the opportunity to study. Each and every child must be given an opportunity to study and learn about the world around, and to acquire more and more skills to express themselves and to contribute to the development of the society and thereby to the development of the country. Everyone must be given an opportunity. So, rights of a person arrested under ordinary circumstances is laid down in the right to life and personal liberty. That means if a person is arrested without any reason, he has the right to approach the courts. No one can be arrested without being told the grounds for his arrest. Without giving him the reason for what purpose he is being arrested, no one can be arrested. And if he is arrested, the person has the right to defend himself by a lawyer of his choice. He can defend himself by appointing a lawyer for himself. Now, right against exploitation. Under this right against exploitation means forced labor is prohibited. All forms of forced labor, they are prohibited according to this right. That means no one should be exploited against his or her will. Because in the past we had vetti or beggar. Vetti or beggar means bonded labor. The people used to work but no wages were paid to them. That is called beggar or vetti. Without any wages, people are made to work. They are forced to work. And if any landlord or contractor forces a person to work without any wages or at very low wages, it is violation of fundamental right against exploitation. That means he is violating the fundamental right against exploitation. And such a person can file a case in the court. Because all these fundamental rights, they can be challenged in the courts. He can file a case in the court. And similarly, if a person is forced to work as a bonded labor, it is also a violation of the right against exploitation, and it can be challenged in the courts. Now, prohibition of employment of children in factories. Below the age of 14 years, the children cannot be employed in the factories where the work is dangerous. It is risky for the children to be appointed in factories or any other hazardous works like mines. So, a law has been made by the Indian government prohibiting children's appointment in any such factories or hazardous works. So, below the age of 14 years, no child can be employed to work in any factory or mines or any other hazardous employment. And accordingly, laws have been also made, and Article 24 of the Constitution prohibits employment of children in any hazardous work. Remember it. Article 24 of the Indian Constitution prohibits employment of children in factories or any other hazardous works. Now, right to freedom of religion. Right to freedom of religion means people in India, because it is a secular state and the government gives equal importance to all the religions, equal treatment to all the religions, all the people are free to follow their own religion, practice any religion of their choice. No one can be prohibited from following his or her religious practices. They can carry on their religious practices, they can practice their own religion. And the person only can decide whether he wants to change over to any other religion. That means they can be converted to another religion also if they want. That provision is also there. They can follow their own religion and their own religious practices, and they can get converted to another religion also. And this right preserves the spirit of secularism in India. Because India is a secular state, this right preserves the spirit of secularism in India. But in the name of religion, no one can commit a crime like infanticide, saying that according to our religion, infanticide is allowed, so we are doing it. It cannot be done. In the same way, in the name of religion, the practice of sati cannot be committed. You might be knowing what is sati. Forcefully burning the wife also along with the dead body of the husband. So, in the name of religion, sati cannot be committed, and in the name of religion, infanticide also cannot. Infanticide means killing the small children who are immediately after being born. Sometimes the parents kill the children. That is infanticide. That is also not allowed. According to the Constitution, of course, there is no state religion in India because it is a secular state and the government treats all the religions equally. Now, right to education and culture. Right to education and culture, it is mainly meant for the minorities. All the minorities, whether based on religion or language, if they are minorities, if they are less in number in population, they have the right to protect and they can protect their language and culture. That right is given to the minorities. According to Article number 29 of the Constitution, the minorities are given the right to protect their language and culture. And in the same way, Article 30 of the Constitution, it provides them That means minorities. All the minorities are provided a right to establish their own educational institutions. If they want to develop their religion or language, they can establish their own educational institutions wherever they are. For example, in Andhra Pradesh, Andhras are in majority, and in Kerala, Andhras will be in minority. When some Andhras go to Kerala and settle there, they can start their own Telugu medium school there for developing their own language. They can start. In the same way, if Keralites come and settle here in Andhra, they can start a Malayalam school here, Malayalam medium school. Like that, they can start their own educational institutions of their choice according to this right to education and culture. Article 29 gives the right to minorities to protect their language and culture, and Article 30 says that all the minorities have the right to establish their own educational institutions. And they have the freedom to establish and run these institutions in order to protect their own culture and language. And the government also has to recognize and provide grants to such institutions. When minorities establish such educational institutions in other states, they are to be protected by the government. By granting government aid to such schools, the government should protect such institutions. And right to constitutional remedies. Right to constitutional remedies means this is the most important right. It protects all the other fundamental rights. Remember, this is the most important fundamental right, and according to this right, all the other fundamental rights are protected. That means, according to this right to constitutional remedies, if any of the fundamental rights are deprived to any of the citizens, they can go to the courts and they can challenge it in the courts and they can get back their fundamental rights. According to this right, they can approach the courts. That means this right is protecting all the other fundamental rights. These rights are very important because this right is protecting all the other fundamental rights. And already we have discussed what is the importance of these fundamental rights. And when these fundamental rights are violated, the people can go to the courts and challenge them in the courts according to this right to constitutional remedies. Against any violation of their fundamental rights, people can approach the courts according to this right. Now let us see public interest litigation. Many a times it is possible that the poorest people or the marginalized sections of the society who are very poor and the poorest of the people in the society, they cannot afford to approach the court because it needs some money. And they don't have money, they are very poor, so they cannot approach the court even if they have any problem, even if their fundamental rights are not given to them. So, in such a case, to make these rights meaningful to everybody, the courts, they have encouraged the people to file public interest litigation. PIL cases can be filed in the courts. What are these PIL cases? Public interest litigation cases. That is, if the rights of a group of people are being denied, then each affected person need not file a case in the court separately. Any person or organization can file a case against the government on behalf of this group of people. Each one need not file a case in the court individually. As a group, anyone, any person or any organization also can file a case against the government on behalf of this group of people. And this kind of cases are called public interest litigation cases. And now these public interest litigation cases are including many other kinds of cases, like including environmental issues because they are related to all the people, transparency of the government, all these treatment of prisoners, because these are related to all the people, they can file public interest litigation cases. Another example, suppose the government decides to construct a dam on a river and 50,000 people are affected by this construction of the dam. Then all these 50,000 people, they want to apply to the government to stop the construction of the dam. But all these 50,000 people need not apply separately, individually. Any one person or any one organization can file a case against the government in the court and they can stop the construction of the project. Now, scope of fundamental rights. To suit to the present needs of the people, the fundamental rights are amended from time to time by the Parliament. As you know, the Parliament can make amendments or changes in the existing rules of the Constitution. That means it can amend the Constitution. And new fundamental rights like right to free and compulsory education, right to information, they have been added to the list of fundamental rights. And these rights can be modified by the Parliament. By adding a clause or by deleting a clause, the existing fundamental rights can be modified by the Parliament. And also the Supreme Court can expand the meaning of particular right through its judgments. For example, right to food. Right to food, the meaning of this right to food has been expanded by and included in the right to life. Because we need food for living. Right to life means right to live. To live, we need food. So the right to food the meaning of the right to food has been expanded and it has been included in the right to life. Now, other institutions and rights. We can trace the origin of these rights to Magna Carta of England. It is a document, and the French Revolution. As you know, after the French Revolution, a Declaration of Rights of Man and Citizens was prepared. And after the two world wars, UNO was established with the objective of preventing wars in future between the countries. And for that, UNO assigned the task to a group of countries. 9 countries were assigned the task of preparing a list of human rights. And these countries drafted 30 articles. And this document came to be known as UDHR. Already we have discussed about it, Universal Document of Human Rights. And it was approved by the UNO General Assembly in 1948. In December 1948, it was approved by the General Assembly of UNO. And all the member countries of UNO signed this document, UDHR, including India. All the countries have signed and are obliged to uphold these human rights and mentioned in the UDHR. That means they will provide these human rights to the citizens of their countries. And through these rights, though these rights are not protected by laws, violation of these rights is considered as a crime at international level. Of course, these rights which are mentioned in the UDHR, they cannot be challenged in the courts. Though they are deprived, we cannot challenge them in the courts. But violation of these rights is considered as a crime at international level. And in many cases, economic sanctions are imposed on the countries violating these human rights. Already we have discussed what are economic sanctions. Economic sanctions means stopping trade with those countries. So the countries which are violating these human rights, trade with those countries will be stopped by the other countries. That means economic sanctions are imposed on that country by the other countries. Now, Human Rights Commission. In 1993, the Government of India passed an act to protect the human rights, and according to this act in 1993, National Human Rights Commission was set up in India. NHRC, in short we call it as NHRC. To protect the human rights, an organization was set up, National Human Rights Commission. In 1993 it was set up. And the commission has been given powers of a civil court. All the powers which are given to a civil court, they are given to the NHRC. And these powers are extendable to the entire country. That means they are applicable in the entire country. And the government has also established other institutions like National Commission for Women, National Commission for Protection of Child Rights, National Minority Commission, State Human Rights Commissions. All these are other institutions which are set up by the government to monitor and inquire into situations. Wherever human rights are violated, to monitor and to inquire into the situations, all these organizations have been set up by the government. And the present chairman of National Human Rights Commission is H.L. Dattu. Please make a note of it. H.L. Dattu, D-A-T-T-U. H.L. Dattu is the present chairman of National Human Rights Commission. And there are human rights commissions at state level also. In India, in 26 states there are state human rights commissions. Now let us see the powers or authority of the NHRC. Children, this is the logo of NHRC. You can see the logo here, National Human Rights Commission's logo, and the chairman, as I told you, it is H.L. Dattu. NHRC is vested with the authority to make an inquiry suo motu means on its own initiative, without receiving any complaint also it can take action. Suo motu action, that means on its own initiative or on a complaint received from a victim or any person on his or her behalf. The NHRC can take action suo motu or on receiving a complaint for a victim or any other person on his behalf or any other relative on his behalf. If any case is pending in a court regarding violation of human rights, the National Human Rights Commission can interfere and solve the case with the approval of such court. With the approval of the court, the NHRC can take up the case and it can solve the case. And from time to time, NHRC reviews the safeguards provided for the protection of human rights under the Constitution. Whatever safeguards are provided for the protection of these human rights, they are reviewed by the NHRC from time to time and also enforces their effective implementation. It makes it compulsory to implement these human rights effectively. Now, violation of human rights. Now, let us see what type of violations can take place. Police excesses. Sometimes police, they go beyond their powers and they harass the people. These are called police excesses. These are all violation of human rights. Examples for violation of human rights. Police excesses, arbitrary arrest. Arbitrary arrest means without any arrest warrant, without giving any reason for the arrest. If a person is arrested, that is called arbitrary arrest. Police excesses, arbitrary arrest. If right to information is denied to any person, right to information is a fundamental right. We have the right to get any information from any government department if we want. If this right is denied, that is also violation of human rights. Denial of right to information and corruption, sexual harassment, and delay in investigation of crimes. If there is any delay in investigation of crimes, that is also violation of human rights. Female infanticide. If a female child is born, immediately some of the parents, they kill them. That is called infanticide. Kidnapping people for ransom amounts. Kidnapping mostly women for ransom amounts. Sometimes children also are kidnapped. Deplorable conditions of women, children and downtrodden people. Deplorable, very pitiable conditions of women, children and downtrodden people. Discrimination which are shown against women in the family. Harassment of women by their husbands, by their in-laws. Cruelty to domestic servants. These are certain violations of human rights. All these cases come under violation of human rights. And these violations continue unchecked because people are not aware of their human rights. If people have some knowledge of these human rights, what are the human rights provided to them, then they can fight for their rights. Because the people don't have any knowledge about these human rights, any awareness about these human rights which are available to them, these violations of human rights are continuing unchecked in the society. And protection of human rights is the responsibility of the government. And complaints about violations can be made to national or state commissions also. As I told you, there are 26 states we have state human rights commissions and National Human Rights Commission at central level. And the chairman of the National Human Rights Commission is H.L. Dattu. And at state level, these cases of violation of human rights are looked after by the State Human Rights Commission, that is SHRC, and at central level they are looked after by the NHRC. Now, fundamental duties. Just like we have fundamental rights, we are enjoying fundamental rights. At the same time, we have some responsibilities also towards our state, and these are called fundamental duties. We have fundamental rights to enjoy, and we have fundamental duties to perform towards our state. It shall be the duty of every citizen of India to abide by the Constitution. each and every person is supposed to follow the constitution and not to insult either the national anthem or national flag. We should not insult our national anthem or national flag, and to cherish the noble ideals which inspired our national struggle for freedom. Our national leaders, they struggled for our freedom with some ideals. To develop those ideals in ourselves also, and to maintain the unity and sovereignty of India, to defend the country from other people, other enemies, to bring harmony and peace among the people of different languages and religions, and to prevent and improve the natural environment, to protect the environment, to value and preserve the rich heritage of our composite culture. We have composite culture because people belonging to many cultures, they live here. So to value and preserve the rich heritage of this composite culture, to develop scientific temper. Scientific temper means to make new inventions. Unless we question how it happened, why it happened, these are some scientific questions. If we develop the scientific temper, it leads to many inventions. So to develop scientific temper, humanism, and the spirit of inquiry and reform. To safeguard the public property. Public property means which belongs to all the people. Government property. To strive towards excellence in all spheres. To struggle to get excellent in all the fields. To educate our children. This has been added to these fundamental duties recently, to educate our children. That means all the parents are supposed, it is their duty to send their children to schools. So these are the fundamental duties which are mentioned in the Constitution. Now here ends the lesson, and I am giving you some homework. Read full lesson and underline all the key points and complete the blanks in the material.